Hello and good morning. My name's Stephen Mather. I'm a solicitor, and today it is World Intellectual Property Day. And so I thought I'd come on and explain a little bit about what intellectual property is, how it impacts small businesses in particular, and what you can do to protect your intellectual property. So World Intellectual Property Day is a day that was set up by the World Intellectual Property Organization, WIPO, to celebrate creativity and ingenuity and those kind of things. Intellectual property, or IP, is such an integral part of sort of modern world, almost from patents up to trademarks, or down to trademarks, maybe, depending on which way you're looking at it. IP covers everything, and we'll go through all of that, and we'll see how you and your small business can really sort of benefit from it. So the copyright, I'll start with copyright. There's a few different types of intellectual property, and I'll start with copyright. So copyright is words on a page, but it can be things like photographs as well, drawings, and things like that. It's basically things that are written down. So copyright happens automatically. So as soon as you've done that, written it down, typed it, made a drawing, made a painting, taken a photograph, written some music, whichever one it is, as soon as you've done that, the copyright exists automatically. There's no need for registration. However, proving that you are the copyright holder is a different thing. So there's no registration. You can't demonstrate that by showing a certificate and saying, here's my certificate, I am the copyright holder. So how are you going to do that in a small business environment? So there's a couple of things, a couple of tricks that people do. So one that used to happen is that you would post whatever it was that you'd created, post it by recorded delivery. So you'd have the delivery slip of it. For me, that's not great. All it evidence is that you posted something. It might show a specific date, but it doesn't show that you created it on that date. These days, we have lots of more easier ways of doing that. Metadata involved in computers. It makes it really easy to demonstrate. Here's a file. Here's when it was created. You can email it to yourself, and you've got a date of when it was created. One thing that I have seen is actually going to a solicitor and getting them to actually certify a specific date and write it down so that you've got that proof from a solicitor that this thing was created on that date. So that's copyright. Once you've done it, it's always a good idea to mark things as copyrighted. So you put that C in a bracket or in a circle on anything that you've done. Now the key bit with copyright and things like I've come across written materials like slides and course materials and things like that. The key bit is, what are you going to do to stop somebody from copying it? So let's say that you're a course, that you've written a course, and people are coming on it and paying you a nice sum of money to come along to the course. And then they've got the course materials. So they take it away and then they start using it. What are you going to do, and how can you stop that? So as well as having the copyright in place and having it really clear that the copyright belongs to you, what I would suggest is that you start to have a look at your terms and conditions of the contract. What I'd suggest you do is have a look at the your terms and conditions or your contract to make sure that within that what I would do is make sure that I would look at your terms and conditions, your contract regarding the piece of work that you're delivering or expecting to deliver. A, to make sure that it's really clear that intellectual property and copyright belong to you. But B, also to make sure that you could do something about it after the event. So you've got a breach of contract claim as well as a breach of or copyright infringement claim. The next area of IP that I wanted to touch upon is patents. And patents is basically an exclusive right granted over an invention. That can be a product or a process. And generally, it's a new way of doing something or a technical solution to a problem. Patents are actually not something that I do on a day-to-day basis because they require quite a lot of in-depth technical information about what's going on, the kind of the science, the technology behind the patent. But what I do know is that is that if you are able to register a patent, then it protects somebody from using that process or that product, that new invention. It stops someone from using it. The downside of a patent is that the patent registration provides all of the information online for somebody to be able to analyze and have a look at, so they can work that back and see how you've done this new thing and then maybe replicate it. Now, there would be an issue of patent infringement if they replicated it directly, but often kind of get an influence. And of course, the patent only exists for a period of time, and so after that period of time, it's then a free-for-all, so anybody can then come to the market with a similar patent. So patents are great if you've got a new product, a new way of doing something, but they are expensive to get, and there's a lot of work going into it. That's why I don't do them. The next intellectual property type is design rights. So a small business in particular, any business, can register the look of a product that you've designed to stop people from copying that design, that look, or stealing it. And the look of the design includes things like the appearance, the physical shape of it, the configuration, or how different parts are designed and arranged together, decoration, and a sort of variety of things like that. So really, if you've created a product and designed a product, and you want to make sure that no one can copy that design, then design rights are a good way of doing that. As an example, I had a case a few years ago now involving design rights, and the design was a sort of laser cut design, a laser cut pattern with a light behind in a frame. Looked really pretty, and that was the design right. And you could buy loads of these things from China, as is often the case. But the design right holder would then turn around and say, "Hey, look, you've infringed my design right." Now, the good thing about design rights is they're relatively easy to get. As long as it's unique, you'd be able to get it. It prevents other people from using that design for up to 25 years. You have to renew it every 5 years, so there's fees involved in doing that. But it does make it quite simple, straightforward to take action. You say, "Hey, look, here's my registered design. Here's your design. It looks the same, or it's so similar as it looks the same. Therefore, stop." The downside of design rights is that they're very hard to, even for me with access to the IPO database, really difficult to check in advance whether or not what you've designed is already registered as a design. So you can type in some words, you can do some reverse image searching, but it's not that great. And so it can be quite difficult. So from a small business point of view, sometimes you can come up with a design and not know that there is already a registered design. You go ahead and make some sales, and then somebody turns around to you at a later date and says, "Hey, look, you've infringed our design right." So difficult to manage. If you are making designs and creating designs, and you want to make sure that no one can copy your designs, then registering a design right is a good way of doing that. In order to register a design right, obviously, first things first, it needs to be a new design. It needs to be something that's unique, and you've come up with. It can't be offensive, so it can't feature graphic images or words. They won't let you do that. Obviously, it needs to be your own design. It can't make use of so-called protected emblems or flags. So things like the Olympic rings or the royal insignia. Those kind of things you can't use. Can't register as a design. Obviously, talking about patents just before now, design rights can't be an invention or how a product works. So you can design the look of it, but you can't register as a design right the way in which it works. And similar to that is you can't protect the functionality of a design. For example, a chair that folds down more quickly than others is not something that you'd be able to register as a design right, because it's just the functionality of the chair that it folds. But the look of it, the decorational piece around it, and the way it looks to the eye, you may be able to register. Final point of IP, intellectual property, that I wanted to talk about and touch upon today is trademarks. So trademark is known as a sign. It can either be a logo or a word, and the whole purpose of a trademark is to distinguish the goods or services of one enterprise from another. And trademarks, I do a lot of trademarks, trademark registrations, and things like that for people. So that tends to be protecting people's brands or companies' brands. For instance, the name of your company, the name of your product, the name of your service. It can be things like Remarkable. That's my trademark. I thought I'd bite the bullet and register it myself. So not the name of my company, but it's a slogan and trademark. Things like should have gone to Specsavers. That's a registered trademark, as well as Specsavers. So there's a variety of different options that you have when looking at registering a trademark. And when you register a trademark, what that gives you, that trademark protection, not only just gives you the R, as you can see above my shoulder, not only gives you the ability to put that on to show people that the trademark is yours, but allows you to take legal action against it. Allows you to sell and license your brand more easily as well. So you're the owner of the brand, and it allows you to sell and license that. So how do you get a trademark? What's the starting point? So like everything else with IP, it needs to be unique. It needs to be novel, is the wording. And a trademark can include words. It can even include sounds. It can be a logo. Can be different colours. It can be a combination of those. Kit Kat at the moment, they're going through legislation, through court proceedings to try and register the shape of a Kit Kat, and they're failing on that. But you can, Rubik's Cube is another one. They're trying to register and having a legal battle about the shape of it as a trademark. So there's a variety of different options with trademarks. Generally, what I see is either a word, like Remarkable, like Nike, like Adidas, or a logo. So if you take Nike as an example, their tick is a registered trademark as well as the words Nike. So a trademark can't be, like everything else, can't be offensive, can't contain swear words or pornographic images, things like that. It can't describe the goods or services that it relate to. So for instance, the word cotton can't be a trademark for a cotton textile company. Really difficult to kind of get that one over the line. Can't be misleading, so you can't, for instance, use the word organic if the products aren't organic. It can't be a three-dimensional shape associated with the trademark. So the shape of an egg for eggs is always difficult to get home and register on, and it can't be too common. It can't be indistinctive. So you can't make a simple statement. You wouldn't be able to register a simple statement like "We lead the way," something like that. It wouldn't be new. It wouldn't be distinctive enough, and the IPO, the Intellectual Property Office, would just reject it. And finally, the trademark can't look too similar to things like flags or hallmarks, royal things, that kind of thing. If you register a trademark, it gives you 10 years, but trademarks can be renewed after 10 years constantly. So that protection that a trademark gives you is pretty good. So if you have a registered trademark, you can stop somebody from selling using the exact trademark. So if you've got a trademark, you can stop somebody from using that exact trademark. You can stop somebody from using a similar trademark as well, something that looks similar, and you can stop somebody from using the same trademark on similar goods as well. To be able to succeed on that, you basically need to, first of all, show that you've got a trademark as a good start, and then if it's not the exact same trademark and it's a similar trademark, you need to be able to demonstrate that there's likely confusion in the marketplace by the public. So the public will be confused or likely confused that new logo or new brand is actually comes from your company. So I help small businesses register trademarks all the time. It's quite an easy, simple process. You come up with the design, the logo, the name or whatever, and then I go away, make some checks, There's a lot of categories that we can register into, so you have to attach the trademark into a variety of different categories for goods or services, or both, depends on what you're doing. And so part of my job is to work out whether or not, or which categories those registrations should go into. What's important with trademarks is that you get it right at the outset, because you can't amend it, you can't add to or edit later down the line, say a year's time. You can't say, oh, actually, no, we're now selling this. You have to make a whole new application to the IPO. So it's really important to make sure that I understand your business, what it is that you're selling, the products, services, etc. As an example, if you are a coach and you've got your course, so we've copyrighted it, we've sorted that out, and now we're presenting. You've got your logo, your brand, whatever it is that you've now got a trademark for, and you want to make sure that no one else can do that. We will be looking at registering it in services as coaching and business management and that kind of thing. But you may be saying, hey, look, I'm also going to be using that to sell books and DVDs and audio downloads and things like that. You've also then got your whole range of merchandise, hoodies and t-shirts that you want to protect against as well. So immediately we're starting to look at a few different classifications there. Another example that I just had recently, they're looking at golf clothes, golfing items. And so when you look into it, golf actually falls into a variety of different products. You can have one for golf bags and golf clubs. Golf clothes, a different one. Golf carts was a different one. So my job is to make sure that we're giving you the full protection of it. Once we're all happy with it, we'll submit it to the IPO. If they're happy with it, and they should be once I've kind of reviewed it and looked at it, they should be happy with it. They will then publish it. Publication is a 2-month process. They publish it online, and that gives anybody the opportunity to oppose it. Opposition to a trademark is usually from somebody that says, hey, look, we've got a trademark that is the same or similar to that, and we don't want you to register it, or more often, we don't want you to register it with that particular those particular product types or goods types. We want to make a change on that. So we have to deal with that. Occasionally we get somebody that says, no, point blank, we don't want to allow that trademark to be registered. And at that point, you've got a couple of decisions to make, a couple of options. One is to challenge that opposition, in which case it goes to back to the IPO as a tribunal, and a decision is made by a tribunal officer as to whether or not to permit your trademark to be registered or to reject the application. Or you can negotiate with the opposer and try and work out a deal to see if you can coexist together and both work in kind of harmony. Often good idea if they're different, but there's an overlap somewhere. We might be able to just spot that overlap and say, okay, look, we're not going to be involved in that product or that sector. Or finally, you might just turn around and say, actually, I don't want any of that. I will come up with a new brand and forget that trademark and go down. And sometimes, that's what needs to do. Obviously, that happens rarely when I'm involved, because part of my job is to make sure that there's no already pre-registered trademarks that are going to potentially oppose your application. So that's it. That's a brief summary on intellectual property on World Intellectual Property Day, April 26, 2023. This was originally intended to be a live video, but technology failed me. Wasn't able to do that, so I couldn't do a question and answer session. But it will go on to my YouTube. So if you've got any questions about intellectual property or about this video, then feel free to ask in the comments below and I'll try and reply, or drop me an email or give me a call. My phone number is 0116 3667 900. My email address is stephen@stephenmather.co.uk, and the website, as you can see right at the top there, stephenmather.co.uk. Thanks very much for listening today. I hope you found it informative, and we'll speak soon. Take care.